And the first, my Lord, is on the distinction between composition and quorum of the IEBC. Indeed, His Lordship Justice Kiage did ask whether composition is the same as quorum, and we submit it is not. The composition of the IEBC is provided for under Article 250, Sub-Article 1, alongside other constitutional commissions, as being a minimum of 3 and a maximum of 9. The specific composition of the IEBC was set at 7 by the IEBC Act, and the quorum, which is the number of commissioners required for it to undertake business, was set at 5 by paragraph 5, Schedule 2 of the IEBC Act. Now, my lords, the challenge by the Commission to the findings of the Superior Court on this issue is firstly based on an allegation that the Superior Court misdirected itself because there was no law requiring a quorum of 5. I would like to disabuse that notion, my lord, by looking specifically at the decision claimed to have declared as unconstitutional paragraph 5 of Schedule 2. That decision is Katiba Institute and others versus Attorney General at volume 1, page 154 to 173 of our bundle.
You see the page?
Page 154 to 173. That's the entirety of the decision.
Right.
But I would like, my lords, if you could go with me to page, if you could go with me to page 165 of volume 1.
Yes.
And this is what the court says at paragraph 73 of that decision. The court says, prior to the impugned amendment, and this amendment, my lord, is the amendment introduced by the Elections Laws Amendment Act of 2017, which sought to reduce the quorum from 5 to 3. Prior to the impugned amendment, paragraph 5 of the second schedule to the Act provided that the quorum was 5, stating the quorum for the conduct of the business at a meeting of the Commission shall be at least 5 members of the Commission. After the amendment, the paragraph now provides that the quorum of the conduct of business at a meeting of the Commission shall be at least half of the existing members of the Commission, provided that the quorum shall not be less than 3. Going down to paragraph 77 of that decision, this is what Justice Chacha-Mwita said. Looking at the amendments and reading the Act as a whole, from the definition of chairperson, election of a member to exercise powers and functions of the chairperson, to the quorum of the Commission for purposes of meetings, it is obvious that these amendments have a negative effect and unconstitutional effect to the functioning of the Commission. To the last sentence in that paragraph, with the above in mind and considering the effect of implementing these amendments, I find and hold that the amendments to the IEBC Act are unconstitutional. It is the amendments that sought to reduce the quorum from 5 that were declared as unconstitutional. And my lord, the Senior Counsel, Professor Gideon Muigai, sought to convince the court that the declaration related to the provision that required a quorum of 5 for the Commission. And the effect of the declaration of unconstitutionality was to completely remove that provision from the law. Now, my lord, before I take you to the consequences of declaration of unconstitutionality, let us assume that indeed Senior Counsel Githu Muigai was right on behalf of the Commission. Let us go to the case of Isaiah Biwott, which they quoted, and faulted the Superior Court for ignoring For clarity, Katiba Institute was decided by Chacha Mwita on 6th of April 2018. 6th of April 2018.
It is at page?
Katiba Institute is the one I've just referred to.
No, I'm talking of the other one.
Biwott is 175 to 185 of that bundle. It comes right after Katiba Institute.
All right.
Now, in the judgment in Biwott, where the Commission was the first respondent, the first paragraph at page 175 says that, sorry, not the first paragraph, this is page 176, paragraph 2, it says the petitioner's case, which is supported by his affidavit sworn on 6th June 2018, 6th June 2018, after the decision of Justice Chacha Mwita on 6th April 2018. In Isaiah Biwott, the IBC does not take the position that paragraph 5 of Schedule 2 is not law. Because in Isaiah Biwott, paragraph 5 of Schedule 2, prior to the amendment that was declared as unconstitutional, is what is in issue. And my lord, if you go to page 181, if you go to paragraph 31 of the judgment in Isaiah Biwott, where the court is interrogating that issue, the court asks, is paragraph 5 of the second schedule of the IEBC Act unconstitutional for offending Article 251 and Article 248(2)(c) of the Constitution? The said paragraph provides that the quorum for the conduct of business at a meeting of the Commission shall be at least 5 members of the Commission. Finally, the court decides that the issue before it, which was to declare that the composition of the IEBC was unconstitutional and to find that the IEBC could not conduct upcoming by-elections, could not stand because by-elections did not require any decisions to be made by the Commission of a policy nature. My lord, the court, as rightly pointed out by, I believe, Justice Tuyot, was that that was not an issue here. The quorum of IEBC was not an issue in Isaiah Biwott. But what is key, my lord, is that
what did the judge say? Did the judge pronounce herself on the issue of constitutionality?
The judge did speak to the issue of constitutionality.
At page?
Of the composition of the Commission. It says, having considered the last page 185, having considered the petition, the Constitution and the law, and having regard to my findings and observations in the judgment, I find that the petition lacks merit and the order commends itself to me to dismiss it. When considering, in determining the constitutionality of the impugned provisions, the court says at paragraph 32, in determining the constitutionality of the impugned provisions, the rules of constitutional interpretation come into focus, providing the guidelines on the manner At paragraph 44 on page 184, this is what the court says. Having regard to the above decision, I do not find any inconsistency between the provision in paragraph 5 of the second schedule of the IEBC Act and Article 251 of the Constitution. Paragraph 5 required a quorum of 5.
What do you make of 43?
Paragraph 43.
Yes.
In the instant case, the petitioner prays for a declaration that the commission is illegal and unconstitutional for lack of quorum as a result of the resignations. The court finds that the alleged resignation was an issue that was neither here nor there and was not proved by any tangible evidence.
All right, so what's your bottom line, counsel, on that authority?
My bottom line is this, my lord, that the commission cannot say that that provision requiring a quorum of 5 does not exist today because of a declaration of unconstitutionality made by Justice Chacha Mwita on 6th of April 2018, when in fact the effect of that declaration was to nullify or void the provisions of the amendment and not what was amended. And that takes me to the effect or consequence of voidance. And I would like to cite...
Sorry, counsel, before you do that.
Yes, my lord.
It's clear from a reading of Isaiah Kibiwot
yes.
that the judge considered the decision of Judge Chacha Mwita in Katiba Institute,
yes.
right?
Yes.
And the bottom line in Isaiah Kibiwot was that even though there had been resignations, the IEBC could still conduct by-elections, etc.
Indeed, my lord, and I do not have an issue with that. And
all right.
The reason...
That's fine, that's fine. So my question is, if IEBC, through no fault of its own, has 3 commissioners, and the court has held without appeal that they can conduct business of by-elections, why can they not conduct the business of verifying signatures?
For this reason, my lord, the comfort that the judge had in allowing the commission to conduct business of by-elections was specifically because by-elections, and she said so in her judgment, by-elections are not a matter that the IEBC has to make, requires decisions of the commission on. They are regulated by legislation. In this case, and it was conceded before my lords and my ladies, that there is no legislation governing the collection, verification, and presentation of signatures for a popular initiative. So that comfort that the judge had in allowing the by-elections, the IEBC to conduct the by-elections, was based on the presence of legislation governing that. But in this case, there is none, and that is an issue that has been conceded before this court.
Counsel, do I understand you to submit that the formulation of the administrative guidelines that eventually were used or was used to verify is a question of policy?
Indeed, my lord. I will therefore, because I feel like the bench is on the same page with me, I will not take too much of your time. I will just lead you to Cooley Thomas, Professor Cooley Thomas, his treatise on the constitutional limitations which rest upon the legislative power of the states of the American Union. And this is at volume 1 from pages 2 to 36. And I will just request, my lords, that you look at the consequence of declaration of unconstitutionality at page 36. And this is what it says. And what is true of an act void in toto is true also as to any part of an act which is found to be unconstitutional, and which consequently is to be regarded as having never at any time been possessed of any legal force.
Sorry, that is page
36 of Volume 1.
Thank you.
And I believe, my Lord, that is why the judge and the parties were still adjudicating the quorum at 5 in Isaiah Biwott long after the amendments had been declared unconstitutional by Judge Muita. I'll proceed, my Lord, to the role of the IEBC in verification of signatures of supporters of a popular initiative, and paragraphs 710 to 763 of the judgment deal with this, includes the findings and the declarations 11, 12, and 17.
Council, can I request that you start on that? You have 15 more minutes to go. At this juncture, we take a 20-minute break. You come and start on that issue.
Absolutely, my Lord, I'm obliged.
Precisely after 20 minutes.
I proceed to the role of the IEBC in verification of signatures of supporters of the popular initiative. The Superior Court dealt at length with the question in paragraphs 710 to 763 of the judgment, and arising therefrom were declarations 6, 7, and 12.
Yes.
It is our submission, my Lord, that it is necessary that there is a legislative framework for the collection, presentation, and verification of signatures over and above the provisions of Article 257, Subarticle 4 of the Constitution. The appellants, particularly the Commission, faults the subordinate court on its findings on this issue.
Not the subordinate court.
Sorry, the Superior Court. My apologies.
Call it the High Court.
The High Court. Faults the High Court for finding that it was necessary that a legislation be in place before a referendum could be conducted. They rely on Article 257, Subarticle 4, and wish that the court, after the comma, replaces the word which with the Independent Electoral and Boundaries Commission. And my Lord, this is an attempt to run away from the first limb of that sub-article, which requires that in addition to the draft bill, the promoters of a popular initiative delivers supporting signatures. It was conceded, my Lord, before you and my ladies, that the Commission does not have a repository of signatures. It was also conceded, my Lord, that there is no legislative framework for collection, presentation, or verification of signatures. Hence, the attempt by the Commission to fill that lacuna by adopting the administrative procedures they did, and which they say they used in the verification of signatures in relation to the bill impugned by the High Court. My Lords, my senior Eric Gumbo went at length to give the steps that the Commission took in verification, what they term as verification of signatures.
Is it verification of signatures or verification of voters, registered voters?
Our submission is that what is to be verified, my Lord, is the signatures belonging to the registered voters. You cannot have a signature without the signee. Now, what the law requires is that the person appending the signature, which is delivered together with a draft bill and called supporting signatures under Article 257(4), be registered voters. And so the commission needs to undertake a process where it confirms whether what it has received as supporting signatures from the promoters are indeed signatures of registered voters. And our submission humbly is that if what the drafters of the Constitution intended was that the verification simply be that this name appears in the register of voters, it would have asked for a list of names of voters. It would not have asked for signatures. And indeed, my Lord Justice Kiage did ask what my senior counsel, Professor Gido Megai, was it? I think senior counsel Tenda Molo was referring to as a unique identifier. How would the IEBC know that that name, for instance, belongs to Esther Angawa, who has appended her signature in support of the bill? And Senior Eric Gumbo read to the court the definition of biometric data, which is what our law identifies in elections law as the unique identifier, biometric, defined as unique identifiers or attributes, including fingerprints, hand geometry, earlobe geometry, retina and iris patterns, voice waves, DNA, and signatures. Of all the unique identifiers that would identify Esther Angawa to the commission, it is only signatures that appears in 257(4) as a requirement to be handed to the commission. It must be verified that those signatures belong to the people they are claimed to belong to. And it has been considered that there is no framework for such. In fact, Senior Gumbo went ahead as to say that to demand, he said that the court, the command of the court, and Senior Gumbo, if it wasn't you, please forgive me, it could have been any of the counsel for the appellants, my lords and my ladies. The submission was made that that command came from the High Court. It was not a command by the High Court. It is a command of the Constitution, Article 257(4) demands that. The appellants took umbrage with the fact that the Superior Court referred to its treatment of verification of signatures in the Okoa Kenya initiative, and more particularly, that the High Court found it startling that the Commission was taking a completely different approach in this case on what it meant for them to verify signatures. My Lord, we urge this court to uphold the finding of the High Court on this question, and we urge you to be persuaded by what this court held in James Omingo Magara and Manson Onyongo Nyamoya and two others, versus Manson Onyongo Nyamoya and two others, 2010. It's at volume 1, page 187 to 210. The particular paragraph being at 199. And this is what the court said, that the verification of voters, in this case, and I'm sure, my lord, the presiding judge are well aware, this being an appeal against your decision when you were a judge of the High Court. And the argument was that the verification of voters is simply a matter of math, or the votes that were attained. And this court held that verification of voters or votes is not a basic exercise, but a matter that requires beyond simple arithmetic ascertainment. The commission submitted here that they ran the names through a program, the names. That is how they verified that the signatures they had received belonged to registered voters. And they attained the number 1 million, and that was enough. We humbly submit that the yardstick applied by this court in Omingo Magara must be the same yardstick, if not higher, for the verification of supporters of a popular initiative. Before I move to the next issue, my lord.
So in precise terms,
Yes.
how should that look like? How should that be done?
My lord, let me begin by expressing my surprise that the commission can come and state that it does not have signatures or unique identifiers of voters in this country, especially because we have a biometric system of voter registration. We have a biometric system of voter registration, and one of the unique identifiers under the Act are signatures. It is incumbent upon the Commission, and more particularly because of the fact that taxpayers pay for the work of the Commission. Taxpayers pay for the biometric voter registration. It cannot lie in the Commission to come and admit that it does not have that which it says in the Act is a unique identifier when we have a biometric voter registration system.
So I understand you to then be saying that the commission should then look at each signature, each signature of the 1 million, and then check that database and satisfy itself that each signature corresponds with that one.
Absolutely, my lord.
If I could just follow, are you suggesting that registered voters who do not have signatures cannot participate, cannot be the support an initiative under sabbatical 1 to make up the 1 million, so that those who do not have signatures cannot participate?
My lord, it is not my suggestion. The Constitution demands that what is presented to the Commission are supporting signatures. If I do not have a signature as a voter, how would my signature end up in the list of supporting signatures to the popular initiative? Unless I'm not understanding your flow, my lord. You seem to ask what would happen to those without signatures, but the Constitution demands for supporting signatures. So if I do not have a signature, what will I be appending on to that supporting document?
What is the definition of a signature in law? You remember that in the Stanley Njindo Matiba case versus Moi, that issue arose whether the petitioner who could not sign because he was paralyzed, whether he could present a petition. You remember that? Mm-hmm. So the question is, a signature is required. What is a signature in law?
My Lord, I could write my name. It could be a scribble. It could be a thumbprint, if that is how that is what I have indicated to the commission, is what identifies me as that voter. When you retire, my lords, please do consider Volume 1, page 343 to 361. Professor Albert Stam on methods of state constitutional reform addresses the same issue, more particularly at paragraph 347. Now, my lord, before I move to voter registration, I think it is important that we look at the arguments given by the commission for not being in a position to do what is demanded of it for lack of quorum. And particularly, my lord, because this bill, the bill that was impugned by the Superior Court, is said to be an initiative of the people. And the commission has come and said that even though it doesn't have quorum, it can still create the administrative procedures for this process. And the court should indulge it, because the question of the membership of the commission is not its fault. And I believe, my lord, you asked me, what if these things happening are not of the fault of the commission? And my lord, it is important to know that in Isaiah v. Watt, the judge said that he decried the late recruitment of commissioners, this lack of quorum being due to resignations. And I think it is important, my lord, for us, just before I move from that point, so that we can understand what the court is being asked to do here when it is asked to overturn the findings of the High Court. The commission, which concedes it has only 3 commissioners, is here saying it can still proceed to do what it needs to do despite the diminished membership. The Attorney General, who is the advisor of government, including the commission, is also here saying the same thing. Let's overlook that issue because it's not the commission's fault. The president, upon whom the responsibility to declare vacancies in the commission is placed by Section 7 of the IEBC Act, is also here. Parliament, whose work is to oversight the executive, is also here, telling us to ignore the fact that there have been vacancies in the commission for more than 3 years and allow them to rely on their administrative procedures, which the commission conceded was supposed to be an internal issue and only came out because somebody wrote a letter asking, how are you going to do this verification? Never once has the commission, unless because it hasn't made any submissions to that effect, stated what handicap there has been, why there has been no recruitment. Not once, not before the Superior Court, and not here. Their submissions were purely, ignore, we can still operate. In the country that we live in, my lords, it is important that we take notice of all those in power who ought to do their work within the precincts of the Constitution and fail to do so, but come here and expect the court to ignore all of that and assist them to continue down that road. Voter registration, my lord, paragraph 764 to 772 of the judgment deals with the issue of voter registration. Our submissions on this are very brief, my lord. Article 38, 3A and B of the Constitution gives any eligible Kenyan the right to vote. Article 82, 1C of the Constitution demands that voter registration be continuous. The Commission has submitted that voter registration has been continuous. Notwithstanding that the Gazette notice filed indicates that that is data as at 2019, 31st of December. My lord, young men and young women are still turning 18 after 31st of December 2019. Old men, young women, middle-aged are still dying after 2019, 31st of December. And the law demands, the Constitution demands voter registration be continuous. The Elections Act, and the Commission read this to us yesterday, Elections Act, Section 5, subsection 1, provides that in compliance with the Constitution, registration of voters and the revision of the register of voters under this act shall be carried out at all times. Before I move to the except, my lord, we submit that there has been no evidence, not before the Superior Court and not before this court, that voter registration is going on or has gone on beyond the 2019, 31st of December.
I thought you were referred to an affidavit of Mr. Goa, where he deposed inter alia that there has been continuous registration, or you say that is not the case?
That affidavit, my lord, is it the affidavit that was introduced in reply to the
No, there was an affidavit. There was an affidavit that was filed in the High Court.
My lord, that affidavit did not provide actual data or information about evidence. I can come here and say that I have been reading 10 judgments a day as proposed by one of our seniors, Steve Ogola, but nobody can establish whether indeed I have been reading 10 judgments a day. Now, I would be more convinced by the Gazette notice that was brought into this court, indicating the numbers of registered voters as at that time. And my lord, it is a matter of public notoriety, really, that there has been no voter registration.
All right, please move on.
My Lord, the appellants have an issue and seek that this court overturns the finding of the High Court that no referendum should take place until there has been mass voter registration, nationwide voter registration. And they say so, this was their submission yesterday, that before the IEBC receives the notice or receives the bill from the president, that issue is not ripe. That was their submission. That they cannot begin voter registration en masse before they receive that notification and actually know that there's going to be a referendum. But what does 5(1)(a), 1(b)(a) say, my Lord? Registration of voters and revision of the register of voters under this act shall be carried out at all times except, when you go to BA, in the case of a referendum, between the date of the publication and the date of the referendum. Move with me, my lords, to section 49 of the same Elections Act, part 5 on referendum. And this is what it says at 49(6). Here I am assuming, my lords, I'm going with the argument that the commission made that these provisions are sufficient for governing the referendum, whether it be a constitutional referendum or an issue-based referendum. So move with me with that, and let's assume that we will apply these provisions to the constitutional amendment bill. And this is what it says: the commission shall conduct the referendum within 90 days of the publication of the question. Now, if the commission is to conduct a referendum within 90 days of the publication of the question, and 5(1)(b)(a) states that no registration of voters can take place once the publication for the referendum is done, when really does the IEBC want all these Kenyans who are eligible to be registered as voters to be registered? What fault do they find in that holding by the High Court, that they must undertake voter registration before a referendum? They are saying they can only do that after they receive that bill from the president. Yet the very provisions that they wish to rely on, should there be need for a referendum, provide a 90-day timeline and the date of publication. It cannot be, my lord. That ground must fall. Public participation. The IEBC, among the other appellants, insisted that it is the plebiscite where the people participate. That is the heart of public participation in a popular initiative. We submit, my lord, and I will not extensively submit on what John Locke and Montesquieu provide in the Two Treaties and the Spirit of Laws, Volume 1, page 240 to 296 and 339. It is our submission, my lord, that public participation is an incidence of the social contract, and it need not be textualized under 257 for it to be effectuated, or for the right to inhere upon the people. And my lord, it is important that we look at the JLAC report and what it said about public participation. Volume 4 at page 1375 to 1559. That's the entire report. But on the question of public participation, this was the recommendation at paragraph 409 of the report at page 1495.
Yes.
I'll read it, my lord. 409. There was need for Parliament to put in place a legislative framework on public participation at both the national and county levels of government.
Where are you, Council?
This is volume 4.
You say page 409, eh?
14, paragraph 409 of the report, but page 1495. 1495.
Yes. Please go on.
The Houses, further, in the absence of specific provisions under Article 257 of the Constitution, provisions should be included in the proposed law or in the standing orders of the Houses to provide for public participation in the processing of a constitutional amendment bill by popular initiative.
Yes.
My lord, we move on to publication of that bill. Page 1501 at paragraph 437. It was observed that in order to avoid any question arising on the authenticity of a bill for an amendment of the Constitution by popular initiative during the processing of the bill at the various stages, a legislative framework ought to be provided for the publication of the bill. Paragraph 437, page 1501. My lord, an amendment proposal through the parliamentary initiative cannot be placed before the House for the second reading within 90 days of its first reading. That is in the standing orders of Parliament. And that was the basis of the controversy in Parliament on whether or not, as Parliament considered the current BBI bill, whether or not that would apply, because the standing orders specifically term it to apply to a bill for amendment of the Constitution coming from Parliament. Now, my lord, Justice Tuyot took concern with the shortened period of 5 days given to members of the public to confirm the list that had been put up by the IEBC of supporters of the initiative. The amendment bill went through Parliament within a month, all 3 readings, committee stage to the readings. It was submitted here that what is not expressly prohibited is allowed, to suggest that to protect the rule of law, to protect order, to protect the interests of the people, to allow them to participate in this process, we must write it down. Parliament proposed that there must be legislation to provide for these gaps that we all seem to see in the process of the popular initiative constitutional amendment. We submit that the Superior Court was proper to find that it was necessary for legislation to be put in place for collection of signatures, for verification of the same, for the same to be taken through public participation, for the people to be involved, not in 5 days or whimsically, depending on which body is making the decision at which time, but so that we all know, all of us, tomorrow, should Esther Angawa wish to amend Article 257 of the Constitution to ensure that we can no longer amend the Constitution, I should know that this is the way, these are the rules of the game. We find no fault in that decision, and we urge this court to uphold it. Finally, my Lord, I will deal very quickly on the question of referendum questions as I conclude, and I'll take you to Section 51 of the Elections Act, which was submitted to be sufficient. And this is what Section 51 says, subsection 1, where a referendum question requires a yes or no answer, persons intending to campaign for or against the referendum question shall form such national referendum committees and constituency referendum committees as are necessary. 2, where there is more than one referendum question, persons intending to campaign for or against each referendum question shall, on the application to the Commission, form one national referendum committee each and one committee each in every constituency for each referendum question. It is not in doubt that the wording in Article 257 is in singular, a proposal for the amendment . Now, let us assume the Commission will apply this section, even where there are many questions, more than one question. A campaign must be for each referendum question. It is our submission that each amendment proposal in the bill even if the same were to be subjected to this section of the Elections Act, would have to be reduced to one referendum question for each amendment proposal. And my Lord, to help us understand why this is important, the need for one, I'll refer the court to volume 6 of our bundle. At page, from page 2141 to page 2160, is text by George Lutz, speaking on Switzerland, which has been extensively cited, particularly by the BBI and Raila Odinga, the former Prime Minister, as the epitome of citizens' initiative. And my Lord, I refer you to page 2148. In the event I forget, my Lord, I would urge the court, and my ladies, I would urge the court to read this entire writing, piece of text, to understand the difference between the popular constitutional amendment in Switzerland and in Kenya. It's quite different from what the appellants wish the court to understand, but because of time, let me just take you straight to 214 at the second paragraph. That should be line 10. The first, under the Swiss constitution, it is their parliament to decide first whether an initiative is contrary to international law or does not comply with the requirements of consistency of form and of subject matter, and if the parliament finds so, then it invalidates that initiative. But these are the grounds that are given, and the reason why there must be a single issue in a single initiative. The first is the requirement of consistency of form and of subject matter, which means that there should not be more than a single issue in a single initiative. For example, one cannot combine an increase in taxes with a limitation on the number of foreigners in the same initiative, because a voter may be in favor of one but against the other, and as a consequence cannot really vote yes or no.
Yes, please proceed.
In conclusion, my lords and my ladies, we submit that the finding of the High Court, based on our Constitution, and further supported by the Elections Act, the provisions of which the appellants submit should govern a referendum, demand that each amendment proposal must be in a separate referendum question. And on each referendum question, my lords and my ladies, the Elections Act demands formation of committees. And what are these committees for? Those committees are to campaign for or against at the national level.
Sorry,
and
that was section what? Two?
That was section 51.
51?
2.
Yeah, 51.2.
Yes, 51.2. One as well, my lord.
Yes.
And the point I wish to make there, my lord, is that we cannot take public discussion, public engagement, public participation outside this process to the ballot as proposed by the appellants. It cannot be an issue of the ballot. That is not where public participation inheres. That is the conclusion of a process that must involve people throughout. And that section 51 is important. That is what those committees are for those discussions. And I dare submit, my lord, those committees seated together with people is an aspect of the Constituent Assembly as they sit and discuss those issues. This amendment, why do we need a prime minister? Why do we need a 7-year tax break? All those are happening in a space of discourse between Kenyans. It is not public participation at the ballot. And the High Court was proper in finding that public participation, civic education, I think perhaps when we use big words, maybe we feel that we're not saying the same thing. When you're campaigning against something or campaigning for something, what would convince my senior Mutuma here? How would I convince him that this is the reason why you should vote for a prime minister? Or this is the reason why you should vote for the judiciary ombudsperson? We must have a discussion. Civic education may have been made a fancy affair by NGOs and civil society and all of that, but it is more than that. And if those provisions on the referendum submitted by the Commission should apply, I see no reason why the appellants have an issue with the findings of the Superior Court. None at all. I rest.